Hello, and welcome to this special Brennan Center for Justice event. For those of you joining us for the first time, the Brennan Center is a nonpartisan law and policy institute that works to repair, revitalize, and defend our systems of democracy and justice so they work for all Americans. I'm Alicia Bannon, director of the Brennan Center's Judiciary Program and editor-in-chief of State Court Report. So before we get started, there's just a few housekeeping notes. First, we'd like to thank the Birnbaum Women's Leadership Center for their partnership on this event. Second, the Brennan Center is a nonpartisan organization. While we can't support or oppose any candidate for office, we can, and today we will, vigorously debate the policies and positions that matter for our democracy. Civility is important to all of us. Those who post rude or intemperate language in our message streams here on YouTube and Facebook will be removed from the conversation. Live closed captioning will be provided, and you can follow along with the conversation on social media with the hashtag Brennan Center Live. Now to today's program. 2 years ago, the Supreme Court upset 50 years of precedent and overturned Roe v. Wade. In one fell swoop, the court eliminated the federal constitutional right to abortion that generations of Americans had come to depend on, claiming that the Constitution's original meaning didn't allow for it. The court's conservative supermajority has relied heavily on these kinds of originalist arguments in a quest to remake American law. And they've been busy. In recent years, we've seen the radical expansion of gun rights and the court's trampling on affirmative action, voting rights, and the power of government agencies. In the current term, among many other cases, the court will decide whether domestic abusers can be barred from owning guns, and the case may turn on 18th century laws. A through line through all of these cases is that women and other historically marginalized groups are facing heightened risks from today's Supreme Court, which is increasingly restricting our modern day rights to the views and values of a distant past. Today, we're going to discuss what originalism means for women, who, by the way, only won the constitutional right to vote in 1920. We're delighted to have this wonderful panel of experts and advocates to join us here today. Madiba Denny is the deputy editor and senior contributor to Balls and Strikes, and author of a fabulous new book, The Originalism Trap: How Extremists Stole the Constitution and How We the People Can Take It Back. Madiba is also a Brennan Center alum, and we're thrilled to have her back for the day. Khiara Bridges is a law professor at UC Berkeley School of Law. Her fourth book, Expecting Inequity, Race, Class, and Reproductive Justice, will be available next year. And Emily Martin is the Chief Program Officer at the National Women's Law Center, where she leads the development of policy and legal strategy across the center's gender justice priorities. So a huge welcome to Madiba, Khiara, and Emily. We're so excited for today's conversation. Madiba, I'm going to turn it over to you to kick us off with a history lesson. What is originalism? Can you explain it? Can you tell us where it came from and how it came to dominate the Supreme Court?
Sure thing, Alicia, and thanks for having me back for the day. So originalism is the idea that the meaning of the Constitution is fixed in time. Originalists argue that there is a single discoverable meaning, and at the moment when the Constitution was ratified, whatever the original public understanding of the document was then, that remains authoritative and has to continue to govern us today. So however the Constitution would have been interpreted 200 years ago, that's still what we're bound by, according to originalists. Now, it was pretty standard for judicial actors to think about history when they were making their interpretation, but the idea that history was the only factor rather than a factor is actually a pretty modern development. Originalism arose as a backlash to the civil rights movement, as legal and political elites who were opposed to social advancements basically sought legal and formal justifications to turn back time and declare that hard-won progress illegal. And then we saw this formalize even more during the Ronald Reagan years, as his Justice Department adopted originalism as its go-to method of constitutional interpretation.
That's so interesting. One thing that really struck me, I know you made this point in your book, that originalism isn't originalist. Like, that's not actually how the framers understood the role of the courts. That's not how judges understood their role for many, many years.
Yeah, it's deeply ironic. Perhaps good branding, but not actually representative of the historical period.
So I want to turn us to talking about the loss of federal abortion rights, because I think that's what probably comes to mind for everyone in this audience when we're thinking about originalism and its impact on women. Emily, could you explain to us how the court used history in Dobbs?
Yeah, so in Dobbs, Justice Alito, who wrote the majority opinion, walked through the originalist theory for why abortion isn't a protected right. So the right to abortion had previously been located by the Supreme Court precedent as protected by the 14th Amendment and the 14th Amendment's due process clause. So in Dobbs, Alito said, well, we have to look at what the framers of the 14th Amendment would have understood when the 14th Amendment was passed. The standard that has been named in some other cases, but was very much reemphasized in Dobbs, is a question of whether a right protected by the 14th Amendment is deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. That was the test that the majority said it was applying. And so Justice Alito sort of walked through kind of a basic math problem of looking to see whether the right to abortion had been protected at the time of the founding and at the time of the 14th Amendment, and concluded that this right was not deeply rooted in history and tradition because at the founding, while abortion generally was found to be permissible before quickening, before movement in the womb, by the time the 14th Amendment was passed, there had been a lot of campaigns actually around abortion, and about 3/4 of states had criminalized abortion, at least in some circumstances, by the time the 14th Amendment had passed. And Justice Alito said, given this backdrop of widespread criminalization of abortion, how can you say that abortion is deeply rooted in the nation's history and traditions? Justice Alito said it wasn't even the case that any court found a right to abortion until a few years before Roe. So there was no conception of abortion as a right that was protected by the crafters of the 14th Amendment, was his argument. He also responded to an argument or set of arguments that were made by historians in an amicus brief to the court that pointed out that in that campaign, those campaigns that led to criminalization of abortions in the mid-19th century, that a lot of those arguments were based on sort of the 19th century version of great replacement theory, the idea that immigrants and Catholics in particular were having so many children that the Americans that those campaigners thought of as the real Americans, the white Protestants, were going to be overrun unless steps were taken to ensure that that they were fruitful and multiplied, including by restricting abortion. There were also a lot of arguments about how women were seeking to enter into the public world in ways that were deeply inappropriate and unnatural, and how restrictions on abortion were part of ensuring that women remained within the family. And so the argument that these historians made was basically you have to take account of what were really constitutionally illegitimate motivations in criminalizing abortion during this period. But what Justice Alito said was, are we to believe that the hundreds of lawmakers whose votes were needed to enact these laws were motivated by hostility to Catholics and women? Alito said, it seems clear that the evidence is they were instead motivated by a sincere belief that abortion kills a human being. Now, I find it easier to believe that hostility toward women, or at the very least, attitudes toward women that we would see now as blatantly impermissible under constitutional guarantees of equality were motivating a lot of lawmakers in the mid-19th century, but Justice Alito found that unbelievable. So what that all adds up to is relying on a legal and political history from which women were really specifically and systematically excluded in order to understand and limit the meaning of foundational guarantees of individual rights. Women being systematically excluded, women of color doubly so. That's the constitutional moment that we look to in determining the scope of these guarantees. And I think that's one reason why the Dobbs decision was so deeply troubling, not only in its result, but in its reasoning and how it got there.
And what could the court have done? Like, what are other ways you could have looked at the history, looked at the Constitution to find a right to abortion? Oh, you're on mute.
Of course I am.
It wouldn't be an event. If
Yeah, whoever used the mute button before today, not me. So other things that the court might have done was look at the principles that the Constitution seems to be on its face is created to protect, including the ways in which through history, through decades, those principles have been understood to speak to the world in which we find ourselves today. So rather than sort of engaging in this counterfactual, what would the men of the mid-19th century have thought about this question being posed in the 21st century, instead looking to what are the ideas around autonomy, around liberty, around privacy, around equality that the Constitution was created to protect, and even more importantly, has been understood to protect sort of the common law of constitutionalism as we as a culture have grown in our understanding of what equality is, of what autonomy looks like, including through constitutional moments of bringing women into the Constitution through the 19th Amendment, of recognizing racial equality as a core value, that those ideas should be the ideas that we are looking at when we're thinking about what does the Constitution mean, rather than instead sort of having this frozen in time question of what would the white men who were defining these rights, what would they specifically have said if we could transport them into the 21st century?
Chiara, I want to pull you into the conversation now. Could you speak to the extent to which the dangers of originalism, as seen in Dobbs, as well as more broadly, is magnified for people who sit at the intersection of multiple marginalized identities, such as women of color? And how are you seeing that play out in some of the recent Supreme Court cases?
Yeah, thank you for the question. I'll just, when we think about people who sit at the intersection of race, class, gender identity, ability, so on, it reminds me of what you said, Alicia, when we began the conversation, that women were unable to vote in the U.S. until 1920. And so there's something ironic, maybe, that the court would look to 1868 when interpreting whether the Constitution, when deciding whether the Constitution protects a right to an abortion. Women were unable to participate in the democratic processes that produced the laws that were on the books in 1868. It wasn't until 1920 that women were able to, again, have a voice in the political process such that their interests might be directly represented in law. But when we talk about women of color particularly, we have to keep in mind that although the 15th Amendment was ratified shortly after 1868, Black people in the South could not vote in meaningful numbers until the Voting Rights Act of 1965 was passed as a result of agitation during the Civil Rights Movement. So when we think about the intersections, not only do we have to think about the disenfranchisement on the basis of sex that took place in this country, but also the disenfranchisement on the basis of race that was not meaningfully addressed again until 1965. So again, something deeply ironic about the court looking to 1868 to determine whether women and people of color have rights that are protected in the Constitution that could protect them from various forms of inhumanity and indignities in this country. And particularly thinking about Dobbs with regard to women of color, it's important to understand, and the reproductive justice framework reminds us time and time again that regulating on the basis of reproduction has long been a means of regulating racial groups. And so when we think about abortion rights are an issue of racial justice for many reasons, but just statistically speaking, Black women are 3 times as likely to receive abortion care over the course of their lifetimes. And so when abortion rights are removed, or when states are permitted to criminalize abortion care, they're criminalizing abortion of a form of health care that Black people disproportionately rely on. And so we are, by declaring that the Constitution does not protect the ability to terminate a pregnancy, disproportionately affects people of color. And we should, of course, be asking ourselves, why is it that Black women disproportionately rely on abortion care? And the reasons for that are tragic. Black people disproportionately bear the burdens of poverty. Black people disproportionately have greater difficulty accessing safe and effective contraception. Black people also are less likely to be able to control the conditions under which they have sex. There have higher rates of rape amongst the Black community, higher rates of reproductive coercion amongst the Black community, higher rates of intimate partner violence amongst the Black community. And all of this is a function of the higher rates of poverty within the Black community. So Black people disproportionately find themselves saddled with unintended pregnancies. Because of poverty, they disproportionately find themselves unable to carry a pregnancy to term and to raise the child in a safe and healthy community. And so they disproportionately turn to abortion care. And so again, Dobbs, in removing the federal abortion right, disproportionately subjects Black people to coercion, to coerce births, insofar as they are more likely to rely on this health care in the first instance.
I'm going to turn back to Madiba now and bring us to the upcoming, or the Supreme Court term that's coming to an end right now. We have a bunch of decisions that are expected to come down over the next few weeks in June. And one of the big ones, I would have thought it would have been out by now, but it's not out yet, is U.S. v. Rahimi, which involves access to guns for people who are subject to domestic violence restraining orders. And so, Madiba, could you give us a breakdown about that case, what it's about, and what some of the different potential outcomes are, and what all that might tell us about originalism?
I would love to. Rahimi is an extremely elucidating, telling case about originalism as a whole. So I'll start by sharing with folks a bit of the background of the facts in Rahimi. Zacky Rahimi is not what one might call a responsible gun owner. This is a guy who was involved in about a shooting per month for like a 6-month stretch. The one that is seared into my mind is the time that he was at a Whataburger with his friend and his friend's card got declined. So he pulled his gun out and started shooting at the ceiling. So this is who we're talking about here. And he was also subject to a civil protective order because of a history of assaulting his former partner. And so we have the civil protective order that, as a term of it, it says you are now prohibited from possessing a firearm. And we also have, importantly, a federal statute that says if you are subject to one of these domestic violence restraining orders, you can't have a gun. And this is a law that has been held constitutional plenty of times. It is something that everyone basically accepted. And it is only now being called into question because of the Supreme Court's embrace of originalism. 2 years ago, in a case called Bruen, the Supreme Court issued a really strict originalist decision that upended all gun regulation jurisprudence. There used to be a two-step process where judges would first look to see if the regulation fell under the umbrella of the Second Amendment, and then if it did, they would basically weigh the interests involved, saying, is the right at issue to the Second Amendment like not being burdened too much for a big enough government purpose, such as protecting women and kids in particular from domestic violence. And so after that, the attorneys representing Rahimi said, well, there is not a historical tradition of state intervention protecting women and children from domestic violence. It is a very novel idea for the government to disarm domestic violence offenders. And as a result, he argued, this meant that the law is actually unconstitutional. It infringes on his Second Amendment rights because there is not a history and tradition of disarming domestic violence offenders. So the originalist argument here is because the government didn't care about violence against women before, it's unconstitutional for them to care about violence against women now. This is the kind of logic that originalism asserts. And shockingly, this was the kind of logic that was accepted by the Fifth Circuit Court of Appeals. So this has now made its way up to the Supreme Court. I don't actually expect, knocking on wood here, I don't actually expect the Supreme Court to affirm the Fifth Circuit's ruling because many of the justices, although not all, seemed horrified during the oral arguments. And there was a great line, I think it was from Justice Elena Kagan, who basically said to the attorney representing Rahimi, but really it was meant for the fellow originalist justices, saying, it seems like you're running away from the consequences of your argument because they're so bad. So that's what we are reckoning with currently because of the Supreme Court's embrace of this idea of historicism above all else, which really puts people's rights at risk when they have been historically marginalized.
It's sort of, they're like the dog that caught the garbage truck, and it's like, what do we do now? Do you think that the justices knew that this was likely to come out of decisions like Bruen? Like, how do you think they're understanding the Fifth Circuit and the case that's coming before them?
I think they either knew or should have known, because it's not a very long train of thought to get there. It's the next stop on the train of thought. Like, of course, if you're basing your assessment of constitutionality on historical moments, then if the historical moment is unjust, now your standard is too. And it seems like this is very transparent and something that advocates have been saying for a very long time. So this is definitely something that if they weren't aware of, they very well should have been.
Right. There have been unjust historical moments in our history. Who would have
Shocking.
thought it? Chiara, I want to bring you back in to talk about one of the blockbuster cases from the last Supreme Court term, which was Students for Fair Admission v. Harvard, which is a case where the Supreme Court held that race-based affirmative action in college admissions violated the U.S. Constitution, violated equal protection. Can you talk to us about, in your view, was this case a fair application of originalist methodology? What does history actually tell us about how the framers understood the scope and reach of equal protection?
Correct. Yeah. So the most shocking thing to me about Students for Fair Admission versus Harvard is not even the outcome. I think we all saw the outcome coming a mile away. But the most shocking thing to me about the opinion was that the majority didn't even pretend to be interested in originalism when deciding that Harvard and UNC's race-conscious affirmative action programs violated the Equal Protection Clause. I mean, it was just so stunning to me because just the prior term in Dobbs, a majority of justices on the court pretended to believe that originalism was an inexorable command, that they must interpret the Constitution according to originalism's demand. However, just one term later, when deciding whether the 14th Amendment, its Equal Protection Clause, permits race-conscious action by government, the court just was completely uninterested in what originalism has to say. And, you know, I'm a critical scholar. I have to think about why it is that the court would be interested in originalism when it comes to abortion, but uninterested in originalism when it comes to race-based affirmative action. And of course, the answer is the policy results, the outcomes, right? An originalist understanding, a very, cramped historical reading of 1868 would lead perhaps to the conclusion that abortion rights were unprotected by the Constitution. But an originalist understanding of the Equal Protection Clause, it would be hard to conclude that the framers, the original meaning of the Equal Protection Clause is inconsistent with a race-conscious program designed to bring people of color into the polity as equals. We have to think about what was happening in 1868. We're coming off of the Civil War, a war that was fought in part to end chattel slavery, and in part, perhaps by some folks, designed to bring formerly enslaved people to recognize their humanity. The same Congress that ratified the Equal Protection Clause was the Congress that approved the Freedmen's Bureau, which was an agency that focused on Black people, focused on formerly enslaved people, and providing them with the things that they perhaps needed in order to begin to build a life in the country. So it seems clear to me that if one was interested in the original meaning of the Equal Protection Clause, one would have to think about how people understood it at the time. And clearly, if not all, but certainly most people thought that the Protection Clause countenanced race-conscious actions, again, designed to bring Black people into the polity as equals, which would lead to a conclusion that the Equal Protection Clause today would have no issue with programs like Harvard colleges and UNC's admissions programs, which were race conscious and intending to bring formerly, historically students from historically excluded groups into these institutions of higher learning. The court did not even begin to interrogate originalist meanings of the Equal Protection Clause in Students for Fair Admission versus Harvard. It is completely missing from the majority opinion. Now, the funniest thing about Students for Fair Admission versus Harvard to me is that Clarence Thomas gives it the old college try. In his concurring opinion, he endeavors to engage in an originalist interrogation into the Equal Protection Clause in order to conclude that race-based affirmative action is unconstitutional. Really bad history, terrible history. I feel bad for historians who read that opinion. Moreover, not only is it unconvincing to historians, it's actually unconvincing to the other justices on the Supreme Court who believe that originalism was an inexorable command in Dobbs versus Jackson Women's Health Organization. No other justice signs on to Justice Thomas's originalist its originalist interpretation of the Equal Protection Clause. So again, this is an example of selective originalism, the court pulling originalism out of its pocket when it leads to the policy results that it wants, and the court leaving, the conservative supermajority leaving originalism just where it is, in the garbage can, when originalism will not lead to the policy results that the majority wants.
And what's been the impact on women of color?
Yeah, so the fallout from Students for Fair Admission versus Harvard is that race conscious programs all over the country are under attack. And many of these programs have worked to benefit either in effect or by intent women of color. One of the first challenges post Students for Fair Admission versus Harvard was to a Georgia program that provided money, venture capital funds to Black women, because Black women get a desperately small percentage of venture capital funds. And so here was a Georgia program that was designed to bring Black women into this sort of industry. And the program was challenged, and just last week, I believe, a panel on the 11th Circuit denied the legality of the program. They said that it was inconsistent with federal law on race. Another program that is under attack is in my state, my adopted state of California. There's a program in California designed to address racial disparities in maternal mortality and morbidity. Black people are 3 to 4 times as likely to die from a pregnancy-related cause as their white counterparts. And so here's a program in California designed to close that gap, eliminate Black maternal deaths. That program has been challenged. The program gives funds to Black pregnant people, Black Pacific Islander people, Black women, Pacific Islander women, and that program is facing a challenge right now. So the shaky legality of race-based programs that are a function of this, the court's disinterest in originalism and Students for Fair Admissions versus Harvard has led to just a broad attack on race, on programs designed to address racial inequality in the country. And many of those programs would have benefited and have benefited Black women particularly.
Emily, I'm going to turn to you next and turn us to talking about state courts, because, we've talked a lot about the U.S. Supreme Court, but we have 50 states. We have 50 state Supreme Courts too. And particularly when we're looking in the reproductive rights arena, for example, post Dobbs, that's increasingly where a lot of legal battles are playing out. So Emily, could you tell us kind of what we're seeing with respect to state courts and state constitutions and how some of these kinds of interpretive debates are playing out in the states?
Yeah, so it certainly isn't a new idea for reproductive rights advocates to look at state constitutions and state courts as a source of protection, but certainly in the wake of Dobbs, there's a new urgency to seeking other sources of legal protections and other modes of judicial interpretation through state Supreme Courts. So there are a few cases that I will mention. One is a case at the National Women's Law Center brought with Americans United for Separation of Church and State, with the help of the law firm Arnold and Porter, on behalf of 14 clergy members from 7 faith traditions against the state of Missouri, challenging the state of Missouri's abortion ban and several abortion restrictions in Missouri as a violation of the Missouri state constitution's protections for the separation of church and state. So in this lawsuit, the plaintiffs argue that their faith calls them to support abortion access because of the critical importance that abortion care holds for health and autonomy and economic security and equality for women and everyone who can become pregnant. And that case points out that in Missouri, when Missouri passed its trigger ban, its law criminalizing abortion at the moment that Roe was overturned, they openly and repeatedly emphasized that this was a religiously based law. They declared in the bill itself that Almighty God is the author of life. the legislative history is full of statements like the biblical side of it makes clear that life occurs at the point of conception. There are references to Psalms in support of the notion that life begins at conception. There's legislators spoke about their own faith as Catholics and why that was motivating this law. So that case is being litigated right now, but it survived a motion to dismiss. And I think it's an exciting example of the ways in which state constitutional protections have new relevance at this moment, and state courts have new importance in really looking to those constitutional protections at the state level as a meaningful stop on the ability of state governments to restrict abortion rights in this moment. The other case that I'll mention, again, it's not an idea being tried for the first time, but I think it's especially reassuring to see this moving forward now. Earlier this year, the Pennsylvania Supreme Court held that Pennsylvania's ban on Medicaid coverage for abortion is a form of sex discrimination that appears to violate Pennsylvania's Equal Rights Amendment. So that is both an important decision in and of itself. It rejected a previous Pennsylvania legal decision that had held the opposite. I think it's a really important affirmation of the really key principle that that protection against sex discrimination, that gender equality and abortion are deeply bound up in each other. There are a lot of states with state level equal rights amendments, and I think those arguments about equality under state constitutions, we will continue to see more of those. And there are other arguments being made under state constitutions as well, under state constitutional privacy protections, under state constitutional protections for personal autonomy and decision-making. Obviously, different states have different ideological makeups on their courts, but it is encouraging to see in a dark time these possibilities at the state level.
Thanks. I'm going to turn it to everybody. We have a bunch of audience questions in the queue, so I want to make sure we leave some time for that. So I'm going to pose one more question to all three of you, and then I'm going to turn it over to some questions in the audience. So my question for all three of you is, what's the alternative? What would a feminist or more egalitarian approach to constitutional interpretation look like? What role, if any, should history be playing in that? And how do we get there from here? Just easy questions. Madiva, do you want to go first?
Yeah, I'll dive in. So in my book, The Originalism Trap, I give this a lot of attention, and I present an alternative model that I call inclusive constitutionalism, because my idea is that the whole purpose of the Constitution is to facilitate the functioning of an inclusive multiracial democracy. That's the whole point as the Constitution has been transformed by the Reconstruction Amendments. And so when we're interpreting any part of the Constitution, we should be doing so through that lens, like through the framework of the Reconstruction Amendment's liberatory goals. I think it is a grave error for originalism to focus our constitutional interpretation on any particular point in time. What we should be doing instead is focusing on these points of principle, like inclusivity, like participatory democracy, like egalitarianism more broadly. And so we should be interpreting the Constitution in whichever way helps us further a more inclusive and just society and the subordination that so plagued the country, continues to plague the country, and that the Reconstruction Amendments were intended to put an end to.
Chiara, would you like to go next?
Sure. My answer is basically like what Madiba said, because, but I don't have the cool language that she has, inclusive, constitutional. I love that. Essentially, I think that when we're interpreting the Constitution, we should ask ourselves, what are we trying to do here? Um, and in my view, after looking at the longue durée of American history, what we're trying to do here is to create a secular, multiracial democracy. And so the Constitution should be interpreted in light of whether recognizing a right or not recognizing a right is consistent with creating this secular, multiracial democracy. And I got to tell you, if you look at the framers, if you look at the time that the Constitution was ratified, or the 14th Amendment or the Second Amendment, the time that these amendments came into being, I'm not sure that's what we were trying to do. And the we is really not even the royal we, because people like me were not part of the body politic in the 1790s and early 19th century. And so I don't think the framers were trying to create a secular, multiracial democracy back then, but certainly after the civil rights movement, certainly after the women's rights movement, certainly after the queer rights movement, certainly after these movements for disability justice and environmental justice and so on and so forth, it seems apparent to me that this country is committed to creating, to being a secular, the best parts of this country are committed to being a secular, multiracial democracy. And so I would interpret all parts of the Constitution, not just the 14th Amendment, with that question in mind. Is this consistent with this goal of secular, multiracial democracy?
I love that reclaiming of we the people. And I know, Madiba, the very title of your book, you have, how we the people can take back the Constitution. And I just think that's such a powerful, powerful concept. Emily.
Yeah, I'm in strenuous agreement with everything Madiba and Kira said. I will serve as an example in answer to your question of what should we do with history. I think about an article that Yale law professor Reva Siegel wrote a couple decades ago now, probably, about the 19th Amendment and how we should look at the 19th Amendment as not just protection against being denied your right to vote because of your sex, but how the sort of long campaign and back and forth that led to the ratification of the 19th Amendment really was understood by both proponents and opponents of the 19th Amendment as being about women's civic participation more broadly, women as public actors, the ability and right and entitlement of women to have full citizenship and to be recognized as folks who are not just situated within families. And I think that article is sort of an example of the sort of deep reading of constitutional moments that help us understand why inclusive constitutionalism is what our history builds to, because it's those moments when we as a country, through constitutional amendment or through sort of deep social movement and change, have recognized that previously, through exclusion, our constitutional project was less legitimate because women, because people of color, because others who were systematically marginalized were not invited into our nation-making process in the same way, that we are correcting for that. And I think telling that story of history, which was really understood at the time of being what we were in conversation about, helps us understand the legitimacy of the sort of inclusive constitutionalism that Madiba's book is talking about.
Thank you for that. I'm going to turn now to some questions from the audience. The first one, and we were just talking about constitutional amendments. Would the Equal Rights Amendment or other constitutional amendments help counter the harms of originalist decisions? Someone like to take it?
Yeah, my answer would be somewhat. I think it would definitely be helpful to have an actual formal commitment to women's equality in the Constitution. It's, again, kind of embarrassing, and it makes it less legitimate that we don't already have that. But I think we've seen through originalist interpretations of the 14th Amendment and the Second Amendment that any amendment can be vulnerable to originalism. So I think that in addition to making these sorts of formal legal changes, we also need to make these changes to the way we think about the law.
I would agree with that. I think that one of the many terrible things in the Dobbs decision was the majority sort of batting away without even engaging really the notion that equality guarantees and protections against sex discrimination have anything to do with abortion. And so you could certainly imagine a world in which the ERA is part of the Constitution tomorrow, where this court says, what does that have to do with what we're talking about? That is completely irrelevant. And so, yes, it would be an important protection. And also, equally as important, more important, is the social movement and the legal conversation that we would have to get the ERA into the Constitution, because that process is the process that helps ensure good faith interpretation and inclusive visioning of what the Equal Rights Amendment would mean.
Right. Well, sort of building on what Emily and Madiba just said, the second audience question, I guess, is sort of asked to go a little deeper about what can advocates do outside the courtroom to stop the rollback of women's rights, to maybe stop what we've been seeing coming out of the U.S. Supreme Court.
I'll begin an answer to this question. One of, I suppose, well, no, I guess it is a good result of Dobbs is that advocates have stopped paying as much attention to the federal judiciary as we once did. I believe that we once believed that the Supreme Court was going to save us. I think we had this nostalgic quixotic view of the Supreme Court as being like the Warren Court of the 1960s. By we, I'm talking about progressives. We believe that the Supreme Court had this commitment to protecting marginalized people of color, women, so on and so forth. But I think it has long been true that the court is not that. And I believe that the conservative supermajority is just, repeating, making it painfully obvious time and time again that the Supreme Court is not the Warren Court. The Supreme Court will not save us. And so I think that as scholars, as advocates, as activists, we've stopped fetishizing the federal judiciary, or perhaps the entire federal government, as much as we once did. And a lot of action is now taking place at the state level. And so we've seen, it's surprising gains at the state level. We've surprising wins at the state level. We saw Kansas reject an amendment to their constitution to eliminate the abortion right. We've seen conservative states, interpret their state constitutions in ways that protect the very, 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 very narrow right to an abortion, right? Abortions that are necessary to save pregnant people's lives. And so there's more advocacy to be done at the state level. And in fact, in 2024, abortion is on the ballot. We will see, the outcomes of all of these referenda that are proliferating in the states about whether and how to enshrine abortion rights or reproductive rights into state constitutions and state law. So I think the action is in the states, and perhaps that is where it should have been, 50 years ago, 20 years ago, certainly today.
And I would add, I think that's right. And also, I think that one reason we find ourselves here is the right's willingness to play the long game in its focus on the federal judiciary and its focus on inculcating these modes of constitutional interpretation through law students to attorneys to judges to Supreme Court justices. And so I think that there's also work to do to ensure that progressives are equally engaged in the project of shifting the judiciary at the federal and state levels because of the importance of that project. But more broadly, it's really important to vote, to organize, and to identify the attacks on women's rights and on gender justice as really very deeply bound up in the broader attacks against democracy that we are seeing across this country, that it's not coincidence that these are all happening at the same time. The attacks on voting rights are really bound up with efforts to roll back reproductive rights, given the majority support that reproductive rights have. And so doing cross-movement organizing and naming gender justice as really a key through line in the fight that we are in the midst of to protect democracy, I think is also part of the answer for advocates beyond the courts.
So, Madiba, please.
Yeah, I just wanted to add just a little bit and maybe integrate a couple trains of thought that I was picking up on. I think the things we're discussing here that folks need to do outside of the courts is like we need to do our best to change the laws, and also changing the people who make and interpret those laws, and also changing the terrain on which we fight our legal battles by doing this sort of culture shifting, organizing, interpersonal work.
So the next question from our audience is essentially, what else do we need to be worried about? Aside from Rahimi, what are some of the other cases moving through the courts right now that could disproportionately impact women and other historically marginalized groups?
Well, we've talked a little bit about, Kiara's talked a little bit about the multi-pronged attack on, I guess DEI is a way to describe it, but on sort of core civil rights principles of equity and inclusion, and the attempts to weaponize civil rights laws and constitutional protections of equality to make it impossible to take steps to open doors of opportunity to women, to people of color, to others who have been systematically excluded. I think we're seeing that effort undertaken using a variety of tools, also working to expand the ability of folks to discriminate in the name of religion, working to expand free speech rights so that there are no protections against harassment, that there are sort of these multi-pronged attacks on core civil rights principles, which may not be before the Supreme Court this term, but are in many, many courts around the country, and where I think we can expect the Supreme Court to be active and engaged in years to come, unfortunately.
I would also note how the Supreme Court is continuing to undermine the ability of people of color to participate in the political process. This has been a very long-standing project, from chipping away at the Voting Rights Act, like getting rid of pre-clearance and like hollowing out Section 2 of the Act as well. But something that I also found deeply disturbing was a recent ruling by the court where they basically blessed racial gerrymanders. They didn't say that. They said, "Oh, it's that courts can't decide the constitutionality of partisan gerrymanders," while completely ignoring the way voting is so racially polarized in this country. And so a racial gerrymander and a partisan gerrymander are essentially the same thing. And I don't really care if you are discriminating against Black voters because they vote for Democrats, or discriminating against Black voters because they're Black. Either way, you're discriminating against Black voters. But that was not something that Sam Alito thought mattered.
I'm going to combine two questions, and I'll let folks kind of answer whichever combinations they want, just because I want to make sure I want to get through as many as possible. So 2 questions. One, the Supreme Court says its decisions are based on an objective reading of history, But should we take that claim at face value? Are there alternative ways to look at some of the history that the Supreme Court has been interpreting? It's the first question. Second question, has big money in politics played a role in the rise of originalism and the erosion of individual rights? So I'll let folks answer whatever combination they'd like of those. Chiara, would you like to go first?
Sure, I'll begin. And I'll I'll address the question about the court saying that it's engaged in this objective reading of history. First, I mean, I think this entire conversation that we've been having has emphasized that the choice to rely on history alone is a choice. It's a political choice. And so originalists and defenders of originalism will say, this is actually apolitical. This is, originalism is outside of politics, but it's important for us to understand that, again, to rely on history, a particular history to the exclusion of any other factor is a political choice. The second thing I would like to emphasize is, just looking at Dobbs particularly, relying on the laws in 1868 is an odd sort of reading of history because the country didn't come into existence in 1868. And actually, if we looked at the laws prior to 1868, abortion was, certainly not criminalized. It actually was not regulated up until quickening. The laws that were on the books in 1868 were the result of a social movement, a racist, xenophobic, sexist social movement. And so, again, looking at looking at one particular snapshot of history divorced from the history that came before is not objective at all. Again, it's a choice. It's a political choice. And the last thing that I'll mention is that the 13th, 14th, and 15th Amendment, the Reconstruction Amendments, were designed to end chattel slavery and bring enslaved, formerly enslaved people into the population as equals. And so if we think of the 13th, 14th, and 15th Amendment as designed to end chattel slavery, we need to ask ourselves, what was chattel slavery? And one narrow reading of chattel slavery is that it was like, compelling people to pick cotton in the fields without compensating them. But another sort of broader understanding of chattel slavery is that chattel slavery was, yes, forced labor, but it was also rape. It was also forced childbearing. It was also denying people the ability to raise the children that they had, right? Making their children, denying them parental rights, and selling their children for a profit. And if that is what chattel slavery is, and if 13th, 14th, and 15th Amendments were designed to end chattel slavery, well, then the 13th, 14th, and 15th Amendments are designed to end rape. It's designed to end forced pregnancy and forced gestation. It's designed to end the denial of parental rights. And so, again, how are we looking at history? Are we looking at it narrowly, or can we have a broader understanding of history? And again, there's nothing apolitical about a narrow reading of history versus a broader one. There was political choices, and the court's protestations that it is engaged in this objective reading of history is just that. They're just, methinks that the court doth protest too much.
Now it's my turn to just be like, agree, co-sign, absolutely everything you just said.
So I guess then we're coming sadly to the end of this hour and this wonderful conversation. So I have one last question that I'm going to pose to each of you, which is just in a few sentences, what is the one thing you want our audience to walk away with this afternoon? Madiba, would you like to go first?
Sure. I'm desperately trying to hone in on just one thing that I want the audience to walk away with. I think I want listeners to know that there is nothing objective or neutral about biology. There is nothing objective or neutral about the Supreme Court's application of it. And we do not need to accept the Supreme Court either as the sole arbiter of constitutionality. We, the people, are the ones who have the final say over what the Constitution means.
Again, one of the hardest questions in the world. two things I want the audience to take away from this. One, please read Madiba's new book, The Originalism Trap. Read it alongside Reva Siegel. We've already shouted out Reva Siegel today. Reva Siegel has a brilliant article called Memory Games. It was published in the University of Texas Law Review. It gives a brilliant history of originalism. And one thing that Madiba's book will teach you, as well as Memory Games, is that originalism is a product of a conservative legal movement that wanted to overturn court cases, precedents that were in the interest of racial justice, that were in the interest of gender justice. But they needed an apolitical seeming way of overturning those court decisions. And they came up with originalism. So again, originalism is political through and through. We don't have to accept any protestation that this is an apolitical exercise. We can understand it for what it is, and we can challenge it on that basis.
And I guess what I would say I want people to walk away with is the knowledge that change is possible and the hopefulness that enables people to organize for change. I think in looking at the current Supreme Court, in reading Dobbs, and thinking about all the ways in which these attacks are showing up on our laws and our sort of basic principles, it's easy to feel a little overwhelmed and hopeless. And I think it's important to leave today by looking at the spots that we have seen over and over and over in this country since Dobbs was decided, in elections and otherwise, of people, of voters coming together and saying this is unacceptable and that we demand a change. And that's what I would like people to leave with, the knowledge and belief that that's possible.
Well, a huge thank you to these wonderful panelists and to our audience for all of your questions. I wish we had time to get through all of them. And with that, I will just say the Brennan Center looks forward to seeing you at future events. You can be the first to know when events are announced. So you can be sure to sign up for the events newsletter at brennancenter.org/events. And I'm Alicia Bannon, Director of the Brennan Center Judiciary Program and Editor-in-Chief of State Court Report. Thank you so much all for coming and for this really wonderful conversation.